Okay. Welcome. We're here to celebrate Michael Dorf and Trevor Morrison's wonderful new book, Constitutional Law, which is part of Oxford University Press's series of introductions to U.S. law. The book approaches the subject matter by focusing on the question, who decides? And imagining constitutional law as a series of debates and judgments about the allocation of decision-making responsibility across a variety of different institutional sectors. We have a wonderful panel as well with us. Our first speaker is Jim Fleming. Jim Fleming is the Honorable Frank R. Kennison Distinguished Scholar in Law. He's Associate Dean of Research and Intellectual Life and Professor of Law at Boston University Law School. He's the author of countless books and articles, including Securing Constitutional Democracy, The Case of Autonomy, which was published by University of Chicago Press in 2006. He's also the author of two forthcoming books, Rights, Responsibilities, and Virtues with Linda McClain, and Fidelity to Our Imperfect Constitution, which is currently under contract as well with Oxford University Press. He's also co-author of Constitutional Interpretation, The Basic Questions, which came out from Oxford University Press in 2007. Welcome.
Okay. Thank you, Aziz. It's a pleasure and an honor to be here today. I've long known and admired Michael for his excellent work in constitutional law and theory. And I've long wanted to meet Trevor as well as Josh. And it's always a privilege to share the podium with my teacher and friend Dick Fallon. I'll begin by assessing the book pedagogically as an Oxford introduction to U.S. law, and then I shall criticize it as a work in constitutional law and theory. The book is an exemplary introduction to U.S. constitutional law. Here are 5 good things about it. First, it is clear, accessible, and efficient, yet it's not so dumbed down that specialists will not benefit from reading it. Second, although it's an introduction to U.S. constitutional law, the book makes judicious and effective recourse to comparative constitutional law. Now, it does so not to invoke foreign law as a source of constitutional interpretation as such, but rather to undermine what we might call necessitarian assumptions in U.S. constitutional law. Assumptions that the way we do things around here just is the necessary way to do them. Third, the book very deftly and instructively puts the question, who decides, and who decides pervasively, at the beginning, in the middle, and at the end. And in doing so, it aptly challenges the court-centeredness of law students and law professors who may tend to assume that it is obvious, even axiomatic, that the Supreme Court decides everything. And it's especially good at demonstrating and criticizing the Rehnquist and Roberts Court's imperialistic insistence upon getting to decide who decides everything. Fourth, the book very helpfully begins its discussion of our institutional arrangements, like judicial review, federalism, and separation of powers, by considering the purposes, functions, costs, and benefits of those arrangements. By contrast, much discussion in constitutional law simply takes these institutional arrangements as a given, as presumptively justified, perhaps even as the way things just have to be. Finally, the book manifests a sound, common-sense understanding of the nature of constitutional controversies. Mike and Trevor, many constitutional scholars and judges write as if certain cases are controversial simply because they rest upon one doctrinal ground rather than another, or because they rest on shaky doctrinal grounds. Mike and Trevor understand that many cases are controversial simply because they involve controversial moral and political issues. For example, They argue that even if Roe's recognition of a right of a woman to decide whether to terminate a pregnancy had been based on the Equal Protection Clause rather than the Due Process Clause, it would nonetheless be controversial. So those are 5 good things about the book, and I see my time is up. No, seriously, I do want to make one criticism of it as an introduction. Though Mike and Trevor acknowledge that in our federal system, states have important powers, they say nothing about state constitutions or state constitutional law as an important part of U.S. constitutional law. There is one citation to Justice Brennan's famous article in the Harvard Law Review in the 1960s calling for looking to state constitutions to vindicate rights that the U.S. Supreme Court won't vindicate as a matter of federal constitutional law, but that's it. Even though there are discussions in the book of topics like same-sex marriage, which are even now being fought out in state constitutional law. Now, I realize it would not be possible to do too much on this, but they could have illustrated state constitutional law briefly with the issue of same-sex marriage, because this is a major constitutional law issue for this generation of law students, and the issue has been litigated for the most part under state constitutions and in state courts. Even if a federal same-sex marriage case like Perry versus Schwarzenegger were to make it all the way to the U.S. Supreme Court and resolve the issue as a matter of U.S. constitutional law, its doing so presumably would not negate the importance of state constitutional law for this issue. Okay? Now, I shall make a few criticisms of the book as a work in constitutional law and theory. Now, Mike and Trevor, I commend you for having a chapter on competing theories of constitutional interpretation. You provide an intelligible sketch of the landscape of constitutional theory, necessarily painting with a broad brush, but doing it well. But I think your discussions of representation reinforcement and originalism are stronger than your treatments of natural law and the moral reading and eclecticism. Now, the trouble with the treatment of natural law and the moral reading begins with your explication of the debate between Justice Chase and Justice Iredell in Calder versus Bull. Calder is commonly viewed as the classicus locus of a recurring debate between natural law and legal positivist conceptions of the Constitution. But Justice Chase did not argue that the Constitution incorporates natural law or natural justice. That was Justice Iredell's rhetorical and, to his mind, derogatory characterization of Chase's argument. Chase himself instead argued that the Constitution embodies, quote, certain vital principles that flow from the very nature of our free republican governments. I think Chase is better understood as appealing to principles inherent in the structure of our form of republican government rather than to principles of natural justice inherent in the moral order of the universe. Practically every generation replays a version of this classic debate in Calder between Chase and Iredell. For example, today, if Justice Breyer were to argue in an opinion or in his book, Making Democracy Work, that the Constitution embodies, and I quote Calder, Chase, certain vital principles that flow from the very nature of our free republican governments, we can be sure that Justice Scalia would deride this argument as appealing to natural law or natural justice. But Breyer, like Chase, would be appealing to principles inherent in the structure of our form of republican government, not to principles inherent in the moral order of the universe. Now, I've said every generation replays a version of this debate, yet you present Calder as if Iredell definitively won the debate with Chase. You say ever since Iredell's views have been understood as canonical. You add the courts have no authority to strike down laws either or other than as inconsistent with some provision of the Constitution. Yet, you yourselves show that the provisions of the Constitution do not resolve all questions concerning federalism, separation of powers, and even enumerated rights under the First Amendment and Equal Protection Clause. And you give extensive treatment of the Supreme Court's interpretation of the Due Process Clause to protect certain unenumerated rights. And you discuss the Ninth Amendment as authorizing doing so. So on your own terms, then, Iredell did not win the debate. On your own terms, his views decidedly have not been canonical. Finally, you say ever since this debate in Calder, no justice has expressly affirmed a belief in natural law, yet both Justice Thomas and Justice Stevens in recent years have expressly affirmed in the U.S. reports their beliefs that the Constitution protects natural unalienable rights. Thomas has invoked the Declaration of Independence as proclamation of unalienable rights to equality and condemning what he views as the racial paternalism of affirmative action programs. And dissenting in Meacham versus Fano, Stevens wrote, I had thought it self-evident that all men were endowed by their Creator with liberty as one of their cardinal, unalienable rights. And he reiterated this view in defending the fundamental right to die in dissent in Cruzan and in concurrence in Glucksberg. Now, the trouble with the treatment of natural law and the moral reading continues, indeed gets worse, with your brief sketch of Dworkin's conception of the moral reading. Dick knew I would be here defending Dworkin. First, the moral reading is not a conception of natural law or natural justice. Instead, it is a conception of what the Constitution is, a charter of abstract moral principles rather than an originalist code of concrete historical rules, and it is a conception of how to interpret the Constitution so conceived. That fidelity to the Constitution requires recourse to political theory to elaborate those abstract moral principles, not, as the originalists claim, historical research to discover the relatively specific original intention or original public meaning of concrete historical rules. The abstract moral principles, though, are principles embodied in our Constitution, not principles of natural law inherent in a transcendent moral order. Second, contrary to your suggestion, Dworkin's idea of the moral reading and his right answer thesis do not necessarily entail a commitment to moral realism, which you characterize as a belief that morality is real. I can't put the matter any better than I did in a book co-written with moral realist Soterios Barber, defending a moral reading or philosophic approach. We wrote, "We do not argue that there is a moral reality. Instead, we argue that the enterprise of constitutional interpretation presupposes that conscientious, responsible interpreters are seeking the true meaning or best interpretation of the Constitution. This presupposition does not entail a claim that there is a true meaning in the constitutional materials themselves, much less a guarantee that there is one. In short, we're making a claim about the presuppositions of constitutional interpretation, not what some readers might interpret as an ontological claim about moral reality." And the same goes for Dworkin's moral reading and his right answer thesis. Okay. Now, finally, the final point I want to make concerns what I'll call unenumerated rights, the myth of strict scrutiny for fundamental rights under the Due Process Clause. The book's analysis of enumerated rights, Chapter 7 on the First Amendment, and unenumerated rights, Chapter 8 on the Due Process Clause, is well done on the whole, but I have two fundamental criticisms. First, this formulation employing this distinction implies that the substance of the First Amendment is more, quote, enumerated in its text than it in fact is. And, indeed, Mike's and Trevor's own analysis shows the degree to which the First Amendment substance is not specified in its text. Nowhere does freedom of speech enumerate a right to burn flags, for example, or a right to association. I think the distinction between enumerated rights and unenumerated rights is overblown, spurious, and indeed bogus under our abstract Constitution of principle, because our Constitution's abstract commitments do not purport to enumerate all the specific rights protected by them. Second, the book's analysis of, quote, unenumerated, close quote, rights, in particular the right of privacy, unwittingly perpetuates the myth of strict scrutiny for fundamental rights under the Due Process Clause. Now, the myth of strict scrutiny for fundamental rights under the Due Process Clause is perpetuated mostly by opponents of substantive due process like Justice Scalia and Chief Justice Rehnquist. The myth is that to trigger protection of a right under the Due Process Clause, the right must be a, quote, fundamental right. If the court recognizes a fundamental right, it applies, quote, strict scrutiny. These are the code words they use, requiring that a challenge statute must promote a compelling governmental interest and must be necessary or narrowly tailored to doing so. Sounds familiar, right? Yet, I defy you to find a single substantive due process case besides Roe that declares that a right protected under substantive due process is a fundamental right, triggering strict scrutiny, requiring a compelling governmental interest, and a necessary relationship between the statute and that interest. Roe said that. Roe's the only case that ever said that. And that part of Roe was overruled in Planned Parenthood versus Casey. Nowhere in any other case protecting a right under substantive due process does the court proclaim that a right is fundamental, triggering strict scrutiny, and all the rest of it. Just go through the due process cases protecting liberty and autonomy, from Meyer and Pierce back in the 1920s through Griswold, Moore versus East Cleveland, on up through Cruzan, Casey, and Lawrence. None of those cases applies that doctrinal framework. Well, whence derives the myth of strict scrutiny for fundamental rights under the Due Process Clause? From the opponents of protecting rights under the Due Process Clause. For example, Justice White's majority opinion in Bowers rejecting a right of homosexuals to sexual privacy. Scalia's plurality opinion in Michael H. Justice Rehnquist's majority opinion in Glucksberg rejecting a right to die, including physician-assisted suicide. And most pointedly, Scalia's dissent in Lawrence objecting to the court's protection of a right of homosexuals to sexual privacy or autonomy. These opponents of substantive due process perpetuate the myth in order to narrow the interpretation of the Due Process Clause to make it harder to justify protecting rights under it. Now, somehow, the defenders of substantive due process have fallen for the myth and have been enlisted in perpetuating it. In any event, the twofold result is, one, to make it harder to recognize rights under the Due Process Clause, and two, to make all cases recognizing rights but not tracking this doctrinal template of strict scrutiny seem problematic, a mess, or a jumble, or confused and unrigorous. Every time the court does not say, using these code words, fundamental rights, strict scrutiny, compelling, necessary, which is to say in every case protecting rights under substantive due process, Scalia, Rehnquist say that something funny or sloppy or illegitimate is going on. To illustrate Mike's and Trevor's complicity in perpetuating this myth, I quote their statement after they point out that after the Roe, the court has not applied strict scrutiny. They say, as consequences of these doctrinal meanderings, constitutional lawyers and lower court judges, not to mention new law graduates studying for the bar exam, may have difficulty saying exactly what constitutional tests apply to laws challenged as infringing various unenumerated rights. But why should that be the criterion for assessing a field of doctrine? I dare say we could say the same about many other areas of doctrine treated in the book. I think students preparing for the bar exam have notorious difficulty preparing for the constitutional law part for this reason. Happily, though, they correct their misstep about the meanderings in the bar exam by observing, nonetheless taking a bird's eye rather than a worm's eye view of the topic. We can see that the court will apply some form of heightened scrutiny to laws that infringe the freedom of competent adults to make important decisions about family formation, childbearing, and bodily autonomy. The bird, as usual, has the better view than the worm. Okay, one last sentence, or one last nail this point down. My larger point here is that our situation under the Due Process Clause is much like our situation under the Equal Protection Clause. In equal protection, instead of having three rigidly maintained tiers that automatically decide cases for us and do not require judgment, we have a continuum of judgmental responses permitting us to make the judgments we need to make. Likewise, in due process, instead of having two rigidly maintained tiers that automatically invalidate statutes or automatically uphold them, as Scalia wants, our cases reflect what Casey and Justice Harlan called reasoned judgment concerning our rational continuum of ordered liberty. And to paraphrase Harlan, no two-tier formula can take the place of such judgment. Thanks.
So our next speaker is our very own Josh Chaffetz. Josh is assistant professor of law here at Cornell Law School. The bulk of his research has focused on congressional procedure. He's the author of numerous articles as well as the book Democracy's Privileged Few, Legislative Privilege and Democratic Norms in the British and American Constitutions, which was published by Yale University Press in 2007. Welcome, Josh.
Well, thanks, Aziz, and thank you all for having me. It's a real privilege and an honor to be involved in this celebration. Not only celebrating a book by two scholars whose work I've long greatly admired, but also being joined by two scholars whose work I've long greatly admired as fellow commentators. And it's a special honor to be up here because this is such a great little book. And I use little not in the diminutive sense, but rather to emphasize just how much Mike and Trevor do in how few words. It really is a remarkable accomplishment. And the first-year students in constitutional law always want sort of a magic bullet, right? Something that'll make all of con law comprehensible, digestible, assimilable, all in 230 pages, and it can be read right before the exam. That, of course, is a pipe dream, but this comes, I think, as close as anything I've ever seen, and that's really a remarkable accomplishment. And in that sense, I second all five of Jim's points about the good things this book does. I should note that I see a bunch of my students in the audience, so this does not absolve you from having to do the reading. Now, the book, as I say, covers so many different areas of constitutional law and covers them all very well. But it leaves me with, in some ways, a more basic question, which is just what exactly, in your view, constitutional law is. So let me try and elaborate on that question. So to me, one of the great virtues of this book is the focus on the question that really bookends it, that provides the title of the first chapter, Who Decides, as well as the final chapter, Beyond the Courts. But in both cases, the focus is largely on what the court has had to say about who decides, and on judicially created doctrines of self-limitation. That is to say, even when your substance questions a sort of judge-centric view of the Constitution, your methodology seems, at least to some extent, to reinforce it. So this leaves me wondering about any number of constitutional provisions that rarely wind up in court at all and that make at most cameo appearances in the book. So for now, I just want to focus on three of them. First, the Article 1 requirement of equal representation for the states in the Senate, as of course entrenched by Article 5. Second, the 19th Amendment. And third, the 22nd Amendment. And I'm wondering to what extent these, in your view, are proper subjects of constitutional law. Now, of course, you could say that the reason that these don't get much treatment is that they don't give rise to sort of constitutional controversies of any sort. That is, either in court or out. Right? That is to say, there's widespread disagreement about the wisdom of some of them, but very few people would argue as a matter of constitutional interpretation that, for example, Wyoming should have fewer than 2 senators or Connecticut more than 1, that women can be disfranchised on the basis of sex, or that a 2-term president is eligible for a 3rd term. Right? So that is to say, it's not just that there are no controversies in court about it, but that there are no controversies at all. That might be one possible response. But notice that to make that response is, in fact, to stake out a very particular claim on exactly what constitutional law is. And specifically, it's to stake out the claim that constitutional law is the study of conflicts over constitutional meaning. Now, that's a totally plausible view. It seems to me that view underlies the way constitutional law is taught in pretty much everywhere I've ever heard of. But notice what that view of what constitutional law is leaves out. So it's impossible, I think, to understand the constitutive structure of our politics without knowing that rural areas are massively overrepresented in the Senate and therefore in the Electoral College. Right? After all, Wyoming has less than 1.5% of the population of California and yet has 100% of the senators of California. Now, this helps explain everything, it seems to me, from energy policy to farm subsidies to transportation policy, and yet it's completely ignored when we talk about constitutional law and the way constitutional law structures our political community. Instead, we spend a great deal of time trying to parse whether some particular enactment of this massively malapportioned body affects the stream of interstate commerce sufficiently to allow it to stand. Or to take a happier story, consider the 19th Amendment. Now, it's true that a few states allowed women to vote before the 19th Amendment was ratified. But nevertheless, the amendment enfranchised half the population in a majority of the states. Yet we largely ignore it in discussing constitutional law, choosing instead to focus on how many hundreds or indeed thousandths of a percent apportionments can vary from the precise 1-to-1 ratio and still meet the Reynolds versus Sims test. And finally, we study Bush versus Gore intently and with righteous indignation, while ignoring the fact that without the 22nd Amendment, we probably would have had a 3rd Clinton term, and heck, maybe in the middle of a 5th Clinton term right now. Right? And I could multiply these examples still further, but I think the point is at least hopefully somewhat clear. And that's that when we talk about constitutional law, we have something particular in mind. I think Mike and Trevor admirably want to say that it's not just about things that happen in the courtroom, but I think even the treatment, the more expansive treatment in their book, suggests to me at least that it's not also just about the most important things having to do with the Constitution, because if it really were, we'd have to focus on these, at the very least, these three provisions I've just talked about, and I think a number more. So I don't really have a good answer for what this thing is that we talk about when we talk about constitutional law, but I haven't just authored an introductory book on constitutional law. So that's my question, my first question to you is, what is the content of constitutional law? Or I suppose another way to think about this is, how did you choose which topics to cover in the book? And then without presuming to know sort of how you would answer that question, I want to think for just a minute about how our methodology in answering a question like that affects our polity. Or to put it somewhat differently, I want to think about audience reception of the book. So you write at page 34, an administration that takes the departmentalist view still nonetheless finds it necessary as a matter of prudence to accept the authority of the courts. Otherwise, it will find its policies subject to repeated reversals by the courts, and repeated defiance will come to threaten the rule of law itself. Now, of course, as a sort of logical matter, you could reverse this, right? You could say, why does the administration have to accept the court's authority in such cases? Why doesn't the court accept the administration's authority? Now, I take it that your answer, at least Mike's answer, because I feel like we've had this discussion before, would be that we as a polity accept judicial supremacy, or some version of judicial supremacy, as a brute political fact. That is, the best efforts of Larry Kramer et al. Notwithstanding, we've fully incorporated into our thinking this idea of judicial supremacy. Now, we accept this idea of judicial supremacy so much that a journalist named Ben Adler could, with all seeming sincerity, in Newsweek about a month ago, write the following. Not so harmless, however, is the GOP pledge to America's promise to require every bill to be certified as constitutional before it's voted on. We have a mechanism for assessing the constitutionality of legislation, which is the independent judiciary. An extra-constitutional attempt to limit the power of Congress is dangerous even as a mere suggestion, and it constitutes an encroachment on the judiciary. Now, maybe I shouldn't pick on Mr. Adler. As far as I know, he writes mostly on ordinary politics, not on law or on the Constitution. So instead, I'll pick on Dahlia Lithwick, who has a JD and writes explicitly on legal issues and wrote a few weeks ago in Slate, Christine O'Donnell explained that, and now she's quoting O'Donnell, when I go to Washington, D.C., the litmus test by which I cast my vote for every piece of legislation that comes across my desk will be whether or not it's unconstitutional, unquote. Now back to Lithwick. How weird is that, I thought. That is italicized. Isn't it a court's job to determine whether or not something is in fact constitutional? And isn't that sort of provided in the Constitution? Nobody tell her about Article 6, Votes Clause. Because where did he get these ideas? And alas, I suspect that the fault lies in ourselves. As lawyers, we're trained from day one to see everything through judicially tinted glasses. And those of us who are law professors, of course, tend to reproduce that training with our own students. And even those few constitutional scholars who look outside the courts often focus on constitutional conflicts that look a lot like adjudication. So I noticed that in your book, sort of the poster child for constitution outside the courts and for non-justiciability is the Impeachment Clause, right? Something that results in something that looks like indictments and something that's explicitly called a trial. And somehow we've convinced the broader public, as reflected in people like Adler and Lithwick, but also precisely by using people like Adler and Lithwick as our vehicles, that this lawyer's constitution is the Constitution. With the exception of a very small handful of political scientists, we're the only people for whom words like constitution and constitutional are actually part of our job title. And so when the public looks for experts on constitutional questions, they look to lawyers, and what they get is therefore this lawyer's constitution. But whether you think this is a good thing or a bad thing, and I have to admit I'm emphatically in the latter camp, note that it's not exogenous to our practices as lawyers or law professors. Indeed, it's an artifact of our practices. That is to say, when we look around and announce that judicial supremacy is a fact of our constitutional landscape, we are creating and ratifying the conditions that make it a fact of our constitutional landscape. I want to just conclude by noting that these questions and challenges come from a deep admiration of what you've done in this book. I have no doubt that this is the kind of book that will be widely read, widely discussed, and not only by lawyers and law students, but by educated lay people as well. And I take it that's a good part of your intent in writing this book. And that's rightly so, for as I've said, I think it's a wonderful book. But if you believe that ideas matter, and I think that most of us here in the Academy, at least on some level, believe that they do, then it's all the more important for us to discuss how those ideas are generated, how they're framed, and how they're going to affect those readers, both in the legal profession and outside. Thank you.
Our third speaker today is Richard Fallon, who's the Ralph S. Tyler Jr. Professor of Constitutional Law at Harvard Law School. He's also the author of countless articles and numerous books, including Implementing the Constitution, which was published by Harvard University Press in 2001, Stubborn as a Mule, which came out in 2009, Dynamic Constitution, Introduction to American Constitutional Law from Cambridge University Press in 2004. In a case book, Constitutional Law, Cases, Comments, and Questions, which is co-authored by our very own Steve Schifrin. Welcome.
Thank you very much. It's a pleasure and a delight for me to be here to celebrate this fine book. I first found out about the book when I was contacted by somebody from Oxford University Press, who, as is the custom, wanted me to write a tribute to the book before I had actually read it. And over time, I have come to be very wary of requests such as this. But in this case, I immediately said yes, because I knew it was going to be a first-rate book, because I knew it had been written by Michael Dorf, who's one of the leading figures in constitutional law of his generation, and by Trevor Morrison, who is one of the leading figures in constitutional law of his rising generation. And the book absolutely does not disappoint. It is a terrific introduction to constitutional law and constitutional theory. I love the first sentence. The first sentence is, many of the central questions in constitutional law ask who decides. And with that question, we find our way meanderingly to Marbury against Madison. But the book sets up the most interesting questions in constitutional law as interesting questions in their own right that ought to be of concern to informed citizens, and only subsequently comes to deal with the doctrine that the Supreme Court has developed in dealing with those questions. So as one reads through the different chapters, you read through the chapter on freedom of speech. At the end, you know a great deal about judicial doctrine on freedom of speech, but you also know a great deal about the fundamental problems surrounding freedom of speech in a society that aspires to be a free society, but also wants to be a society of ordered liberty rather than a society of all things go liberty. I could say the same thing about equal protection. I could say the same thing about the chapters dealing with the structure of government. There is a lot of discussion of doctrine, but there's also a lot of sophisticated discussion about what the real underlying problems are, who cares, why people ought to care, what courts are good at doing, what courts aren't good at doing in answering these questions for us, and so forth. And so if somebody came to me, if a law student came to me and said, what's the best introduction to constitutional law, I think I would probably say this book. More than that, if somebody came to me and said, you're a law professor, what do you do with your days? What do you read about, talk about, think about, teach about? What are the kinds of questions that you deal with in the classroom? I would say, read this book. After you've read this book, I hope you'll be excited. If what you read there doesn't excite you, then you would think my days are very boring days, but these are the kinds of questions that have kept me professionally energized for about 30 years. So, now I've said this, and now it is one of the peculiarities of occasions such as this, that now I must find bad things to say about the book, because it would be as boring. It would be even more boring if I went on in the vein that I've been going on in. And so I will make some criticisms, but the criticisms that I make are very similar to those that Josh and Jim have made already. I'm going to put just a slightly different spin on them and put just a slightly different spin on them in the following way. It's going to be my thesis that the book that Mike and Trevor have produced is absolutely state of the art with respect to what constitutional lawyers, constitutional law professors who also want to do constitutional theory do. It's hard for me to imagine it being done much better. But when I see the work being done in this sort of state-of-the-art form, it holds up a mirror to what those of us in the legal academy teaching constitutional law and constitutional theory are doing, and some limits in what the rest of us are doing seem to me to be exemplified by this generally exemplary book. So I'm going to offer three criticisms along those lines. The first of those criticisms is one that both Jim and Josh have made in different ways. I would say I think the book is a little bit weak in its jurisprudential dimension. It talks about what citizens do when citizens debate. More than that, it talks about what the Supreme Court does when it decides cases. It's taken for granted that what the Supreme Court is doing is somehow law-governed, that what they produce is somehow law. But in what sense is what they do law and law-governed? So early in the book, they throw out the so-called attitudinal model put forward by political scientists. Political scientists turn out to be able to do a distressingly good job of predicting how Supreme Court justices will do solely on the basis of their ideology as measured in what newspaper editorials said about them at the time they were appointed. And the basic thesis is conservatives vote conservative, liberals vote liberal. We get 5-4 decisions all the time. Who should be surprised? Here's the reason why the justices vote their ideologies. In response to this, Mike and Trevor say, I think rightly, that this kind of an approach, the attitudinal approach, is no good to a justice who has to decide how should I vote in any particular case. But there's not a whole lot of advice to the justices about how they ought to vote in a particular case. And the point about advice comes through even more clearly when they deal with the various theories of constitutional interpretation that Jim Fleming was talking about. And they tick through originalism. Well, that's not. There are real problems with originalism. It won't do. Natural law or a moral reading of the Constitution. Well, there may be something to that, but that's not quite right. Eclecticism, they say, is another possible approach, but they've got problems with that. At the end of the day, they've held up all of the leading approaches to constitutional law, all the leading approaches to accounting for exactly what constitutional law is. They've said none of them is good enough. They haven't said what would be good enough. They leave us with the strong sense that they believe that there is real law there in constitutional law, but they haven't given us an account of what exactly the nature of that law is. And when I say this, you'll see that I'm very closely at this point tracking what Josh was saying as well as what Jim had said. Second weakness, I think, is that the book is relatively weak on political science. On university campuses today, it's very striking that law and constitutional law are being studied intensively in two fora. One is the political science departments. The other is the law schools. If you read the political science on what the Supreme Court does and you read what law professors write, you would scarcely believe that they were doing the same thing. But there they coexist, and it seems to me it is just virtually inescapably, irreducibly the case that the people in the political science departments would have something to teach us. Within the political science departments, as I understand it, there are two major threads of what people are saying. One is the so-called attitudinal model, or other models that political scientists develop to try to predict how Supreme Court justices, individual Supreme Court justices, will vote in particular cases. Mike and Trevor give that somewhat the back of their hand. The other thing that people in political science departments are doing that to me is potentially a good deal more interesting and in some ways is totally contrary to what people are doing when they propound the attitudinal model, is to ask the question, and I think this is implicit in some of what Josh was saying, how in a political democracy does it come about that people put up with judicial review? Just as an empirical matter, how does it come about that people put up with it? And when they begin to theorize about this, they begin to theorize in various interesting ways. Some of the theorizing goes to the effect that the limits of judicial power are politically constructed. There are some things courts just know intuitively they can't do. They couldn't get away with it. The political branches and the people wouldn't let them do it. They can't order that the president ought to fight a war. They can't hold that Social Security is unconstitutional, even though there would be arguments from an originalist perspective that it is. They can't hold paper money unconstitutional. The people just wouldn't put up with it. And other political scientists working in a similar vein talk in great detail about how it comes about that the kinds of people that serve on courts get appointed to serve on the courts, what courts can do that will resonate sufficiently with surrounding political currents so that their handiwork will last, what they can't do if they want their handiwork to last, what kinds of judicial decisions tend to come unraveled under the fact, after the fact. Maybe the Warren Court's criminal procedure decisions are a good example of that kind, and so forth. So I don't think that Trevor and Mike talk about these things anywhere nearly as much as they might. And then my third criticism is the obvious one. It pulls these two things together, and it says that if we want to understand in a sophisticated jurisprudential way what constitutional law is as law, certainly we ought to be trying to find some way to integrate the political scientists' understanding of the way our political and legal system work into our understanding of what law and constitutional law is. So that's the third criticism. Now, I'm sure that standing up here, and I really am eager to hear Mike and Trevor stand up here to respond to all the things that have been said, not principally to what I have to say. One of the things that they will say is it's a short book. And of course, this is true. It is a short book. You can't do everything. And they will say, we made our choices. And then, but I think they're likely to say, but you know, we made our choices pretty much in the way that other people make their choices, writing about constitutional law. This is state of the art. They won't say that, but that's what I'll say. This is state of the art. This is the way that other people understand the enterprise of constitutional law. They may say, well, we don't need to do that because other people in the legal academy are doing some of that. Ronald Dworkin is terrific about jurisprudence. Jim Fleming writes in a very sophisticated theoretical way about constitutional law. Emily Sherwin on your faculty here at Cornell does terrific jurisprudential work. And then they could say, and there are other people doing this first-rate political science, Bruce Ackerman at Yale, Darrell Levinson is the name I was searching for at NYU. And then there are other people who produce work that some constitutional law professors could use, including on your faculty here at Cornell. Again, Ted Eisenberg, Stuart Schwab, Eric Ruklinski. So the work is being done. I would just say that, yes, that work is being done. The problem I think I now see when I think of this as being an exemplar of state-of-the-art theory is that the people who are doing the best jurisprudence jurisprudential theory aren't paying so much attention to what the political science people are doing, and it's not all pulled together anywhere that I know of in a sophisticated way by people whose central focus is constitutional law and theory. And so that's pretty much my bottom line. The book is terrific as what it is. It's so terrific as what it is that we ought to look at it and say, this is the best of what we who teach constitutional law are doing in the legal academy, and wonder if there isn't more that we ought to be doing. And so I think of myself as one generation of law professors. Jim was my student. Call that another generation. Treat Mike as another generation, and Trevor is another beyond that. They've got time. They've got energy. Are you going to give us the book we really need?
So is this microphone working? Okay. So what Trevor and I have decided is that in rough proportion to how we wrote the book, I'll answer Jim's comments, Trevor will then answer Josh's, and then I'll answer Dick's, and then we may have a little bit of things to amend. So first, let me just begin by saying how great it is that such a distinguished panel took the time not only to read, but to comment on and say those very generous things they said before they said the other things. And that I agree with Dick. It is a very, very strange custom that we celebrate these books by finding all the things that are wrong with them. Let me briefly see if I can respond to Jim. So on the point about state constitutions, yeah, I think I'll confess it would have been nicer if we might have used some other illustrations. Partly we didn't want to confuse people into thinking that state constitutions are required by federal constitutions. But we could have made that clearer, and maybe in volume 2.0 we'll add something about state constitutions. On the core points of disagreement, or Jim's core criticism, I guess I want to say that I feel a little bit like Trotsky being denounced by Lenin. That is to say, this book is very sympathetic to the position that Jim articulates. So let me give you a couple of examples. So take the sentence that Jim quoted about Calder against Bull, where we write, ever since Calder against Bull, Iredell's views have been understood as canonical. Courts have no authority to strike down laws other than as inconsistent with some provision of the Constitution. And Jim says we've sort of given away the natural law side of the debate. But the very next sentence, admittedly in a new paragraph, but it is the next sentence, says, yet if Calder against Bull eliminated natural justice as a freestanding basis for judicial review, principles of natural justice and natural law, terms we will treat as synonymous, although they have been used to connote somewhat different ideas, have nonetheless played a substantial role in American constitutional law. And so I think that most of the evidence that Jim takes as inadvertently or unwittingly undermining our thesis that Iredell's views are canonical was actually intended to illustrate the counter-thesis that Chase's views survived. That Chase, in a sense, lost the battle but won the war. And so on that sort of core point, I want to say that we're pretty much in agreement. I'll give you another example of this. So Jim accuses us of playing into the hands of the unenumerated rights skeptics by having a chapter on unenumerated rights and enumerated rights. But we acknowledge that this is a customary division, but one that we don't agree with and one that we're actually trying to undermine. And so here's a sentence from page 156. The implementation of enumerated... So we've just talked about enumerated rights. We've talked about the First Amendment and how so much of it is contested. We say our core point would apply with equal force to other enumerated rights. We contend that enumeration by itself only goes so far, for the rights enumerated do little more than identify constitutional values, right? So right? Something like flag burning is not mentioned in the First Amendment. That's just identifying a value. The implementation of enumerated rights instead depends on the generation of doctrines not easily deducible from the constitutional text or its original understanding. In that respect, the constitutional law of enumerated rights is not different in kind from the constitutional law of unenumerated rights. So there too, I think that we're basically in agreement, although we didn't say it quite as forcefully, perhaps, as Jim might have liked. Finally, on what I take to be a point that Jim was making, both about Chase and about Dworkin, I think here we may have an actual substantive disagreement. That is, I heard Jim to be saying something like the response that Rawls gave to his critics when he wrote Political Liberalism. Right? In A Theory of Justice, Rawls identifies, right, the veil of ignorance and all these ways, the ways in which you're supposed to derive principles of justice simply from what seem like abstractions. And then critics come along and say, well, your people behind the veil of ignorance actually have real values. What's the connection of that to real societies? And Rawls responds in Political Liberalism, oh, no. You got me wrong. I wasn't deriving universal principles that will govern any imaginable society. I was deriving and saying something about the principles of Western liberal democracies with which we are familiar. And so, too, Jim says that's what Chase is doing, that's what Dworkin is doing. And I guess I don't know, Trevor will have to speak for himself, I'm more of a skeptic than either Rawls or Dworkin or Chase or Fleming, in that I think that even if you are deriving principles about our society, if they are as contestable as they turn out to be, and contested as they turn out to be, then the original criticism of something like A Theory of Justice still has considerable force. That is to say, you are putting your own values in behind the veil of ignorance, and these aren't necessarily values that are shared universally, even within the particular society, although Jim and I probably would agree on those values among ourselves. Okay, so that's what I have to say in response to Jim. I'll turn it over to Trevor for some thoughts on Josh's remarks.
Okay, thanks. Let me just first echo Mike's thanks for this session and for the terrific comments from the commentators. They were, I thought, all great, and it's perhaps embarrassing to say that I learned a lot from people talking about a book that I helped write, but I did. And I want to also say just what a pleasure it is for me to be back here with all of you. The time that I was on the law faculty here at Cornell was a terrific time for me, and I, in many ways, feel like I'm still part of your community, and so I'm glad to be, at least for a day. So I agree with what Mike said about Jim's comments. Maybe I'll just add one small thought on the last one before moving to Josh's thoughts. I think it's right. I mean, my sort of take on the modification of the Dworkin thesis to sort of ratchet down its overall ambition is similar to Mike's take. That said, I think that Jim may have a point that the book could do a better job making the best possible case for that argument than we do. I mean, I think that we have tried in this book, and I know that Mike does in his own work and I do in mine, to try and provide the strongest possible argument for the points of view that we're going to disagree with. And it might be on that one that, you know, if we had used the Fleming account of Dworkin et al., we would have provided a slightly more persuasive account of that with which we ultimately disagree in the book, or at least find to be unsuccessful. So I don't think that dramatically changes where I am on that, but I thought it may be worth saying. As to Josh, I found myself just wanting to say amen most of the time as he was talking. It's certainly the case in my own work that the parts of the Constitution not touched or barely touched by the courts are, to me, more interesting and more important, in part because of how understudied they are by constitutional lawyers and teachers and scholars. And so I absolutely agree with what Josh has said. His own work in this area, I think, is terrifically important, and he's one of a few young scholars doing really interesting work in this area, and I look forward to more of it, and I think it may well be the case that in 2.0 of this book, there's more of that extrajudicial constitution. Why does the book look the way it does now? There is a bit that Dick anticipated at the end of his comments that I think might descriptively be in the nature of the answer here. But let me come at it by taking up Josh's question. What is constitutional law? Even as framed like that, that's two questions. That's what is the course constitutional law, and what is ultimately the substance of constitutional law, or in the light of his comments, maybe the scope of constitutional law. And I think that in some ways, it's not a justification, and maybe it's an excuse that the book's sort of answer to that is dominated more by an answer to what constitutional law is as a course than what it ultimately is conceptually as a substantive matter in terms of its full scope. Now that's, ultimately unsatisfying to me. When and each time I, get ready to teach constitutional law, I think about switching casebooks, and have switched a couple of times now, because I find that none of them come anywhere near devoting as much attention as I think ought to be devoted to the Constitution that happens outside the courts. And so I end up, to my students' frustration, assigning hundreds of pages of memos from the Office of Legal Counsel, or veto statements, or debates from Congress, etc. And as Josh well knows, there's a rich tradition there, or many traditions there, that can lay claim to being part of what constitutional law is in some broader sense, at least as much as judicial doctrine. The book, is intended to supplement students' already existing study of constitutional law, and in a way just compounds the problem, and maybe underscores some of Dick's points as well, to say that's not part of what is conventionally covered in constitutional law courses. I think it's the case that a book like this could be a sort of invitation to expand the scope, and if it did, it would certainly fit a lot with what I spend the most of my time doing as a scholar, which is not really to focus, at least principally, on the judicially implemented Constitution. So with that, I agree. As for debates, then I think Josh makes a second point, and let me agree with it too and highlight it, and that is. He came at this in two different ways. One is to talk about what we say about departmentalism as against judicial supremacy, as the sort of two views of the relationship between the courts and the other branches in constitutional interpretation and implementation. He anticipated what I think is our answer as for why judicial supremacy has the pride of place that it has, and that's a kind of, over time, a broad social and political and cultural, ultimately, acceptance of the role of a court. But he's also right to point out that the public, broadly speaking, and even a lot of people whose job it is to work in this area, vastly sort of overstate what is entailed in judicial supremacy. So whether it's Dahlia Lithwick or others, or for that matter, and this is only because I'm currently writing a review of this book, but Bruce Ackerman, no court-focused scholar has this new book about which he calls The Decline and Fall of the American Republic, which is about sort of why offices like the White House Counsel's Office and the Office of Legal Counsel are bringing the end of the world. And one thing he worries about is a newly aggressive presidency that would challenge what he calls the de facto monopoly of the Supreme Court in constitutional interpretation, or would displace the court as the sole source of constitutional legitimacy. Now, I don't think the court has ever been either of those things, in part because there are vast domains of judicially unenforced constitutionalism, in part because, as President Jackson's veto statement on the bank amply tells us, and as we talk about in the book, the fact that the court will not declare something to be unconstitutional does not stop the other branches from enforcing that more robustly. And let me just then say, since we talk about that in the book, I hope that we do give at least a sort of slightly better than average account of the nuances between departmentalism and judicial supremacy, and the role that the political branches do have, especially in areas of under-enforcement or even non-enforcement. But Josh's last point is a really important one, and that is, when the way students study the extrajudicial Constitution in an ordinary con law class is through things like the political question doctrine, it can be quite misleading. Because the thing about all of those political question cases is they're cases. They came to the court. they were almost justiciable in some way. They had the properties of a litigated case, adversarial presentation, etc., right? It's just that they had to do with some provision that the court has concluded lacks judicially manageable standards. Although, as Dick has rightly pointed out in some of his earlier work, the one thing you can say about the court's jurisprudence of judicially manageable standards is that it lacks judicially manageable standards. So this is a problematic area, but the thing is that to the extent that it might lead students to think that what the political branches do when they do the Constitution is sort of case-focused, it can be really misleading. Most of the constitutionalism that is done by the executive branch or by the legislative branch are not done through adversarial presentation of something that either really is a litigated case or controversy or almost is. And I think that's quite right. And I think if there's one thing that I hope version 2.0 of the book does, it would be to underscore that very important point. Thanks.
Okay, I'll be briefer with respect to Dick's comments because Trevor touched on some of the ground that they covered. I just want to say two things. So first, the first is an advertisement with a substantive comment. So at 4:15 today, Dick is going to be presenting a paper in the Constitutional Law and Theory Colloquium on the moral costs of keeping Americans safe. It's a terrific, interesting, provocative paper, and it should be a great time, especially because then I'll get to ask the hard questions. And so I invite all of you to please come. And there's information about it. And if you didn't get the paper when I sent it out last week, just email me and I'll send you new copies. So a few weeks ago, Barry Friedman and Aaron Delaney presented a paper in our colloquium on one of these questions, right? It's addressed to the question that the second question that Dick talked about that political scientists addressed, namely, why is it that the people accept, political actors especially, accept judicial supremacy? And they have an interesting theory, something that I labeled, it's a genie in a bottle theory. In fact, it got me so interested, I'm writing a paper for a little while later called Genie in a Bottle Theories, or possibly Frankenstein's Monsters Theories. You can worry about that later. But the basic idea is that political actors like judicial review because it's a means of controlling the states, but then the rhetoric of judicial supremacy used to control the states gets applied at the horizontal level and sort of comes back to bite them. So it's a thesis about the role that federalism plays in fostering judicial review. It has obvious problems like, well, why is there judicial supremacy in certain unitary states, for example? And that's, I guess, for their version 2.0. But I want to basically second Dick's point that this sort of question, right, the sort of question that the political scientists are focused on, does belong in a proper study of the Constitution, constitutional law, in a somewhat longer book. And so let me say one way in which I'm trying to address that kind of question in another paper I guess I'm basically done with, but it's not out yet. So there was a conference at the University of Pennsylvania last spring on the Constitution and public opinion. And it was centered around Barry Friedman's book, The Will of the People, the core thesis of which is, basically the same thesis as Robert Dahl had more or less 50 years earlier, right, which is that the Supreme Court follows rather than leads public opinion, is very much constrained by public opinion. So my paper, which is titled The Majoritarian Difficulty, asks the question of how is it, how do we justify judicial review given that all of the leading theories of judicial review depend on the court being a somewhat counter-majoritarian institution. Now that's partly because Bickel and that generation problematized judicial review as counter-majoritarian, and so our leading theories are theories that justify counter-majoritarian judicial review. But nonetheless, those are the theories we have. And so I run through them, and I basically conclude in this paper that each of the leading theories, save one, has the problem that it justifies a more robustly counter-majoritarian form of judicial review than the court is really capable of, certainly in times of political pressure. The one exception that I hold up is a family of theories that I call third legislative chambers theories, of which I take as exemplary the one that Dick has relatively recently written about in the Harvard Law Review in response to Jeremy Waldron's criticism of judicial review. So Waldron has a piece in the Yale Law Journal called "The Core of the Case Against Judicial Review," and Dick has a response in the Harvard Law Review called something like "An Uneasy, Tentative Core of the Defense of Judicial Review." It's catchier than that. And so he defends it as, it's a kind of additional veto gate. And this, I say, is not fatally undermined by the only weakly countermajoritarian nature of judicial review, but it does have a further difficulty, which is that it doesn't specify what the content of that theory is, right? That is, a third legislative chamber theory of judicial review justifies a practice of judicial review. It doesn't tell you what it's going to look like or where the substance is going to come from. And in that respect, it's the same. It has the same problem as Dick identified in our little jurisprudential section, right? Which is, now you're back to the existing theories, and so which one do you pick? I mean, our defense in the book for not sort of coming down with, the one we like, was basically we didn't see that as the role of this book. And I think it's obviously a very hard question. My own view is that none of them is fully satisfactory, and that's not entirely surprising. If there were a fully satisfactory theory, I think it would have won by now. Which sounds a lot like an economist saying, no, that's not a $10 bill on the ground, but I'm going to say it nonetheless. Okay, we're eager to hear questions, comments directed at any of the speakers or us. Or actually, that should be your job to say that, Aziz.
The myth of strict scrutiny for fundamental rights under the Due Process Clause.
And secondly, I just wanted to comment, and I think you're very close, Fleming, in the book, in that I think if you look at political liberalism, that it's fair to say that our community believes in equal liberty, it believes in equality except when it doesn't, and it believes in freedom except when it doesn't. And that there are some results that can be ruled out by looking at our community, such as you can't overrule the winner-take-all system, you can't overrule the Senate, despite the fact that a convincing theory of equality would rule both out. On the other hand, it strikes me that you can plausibly say that in resolving most of the issues that are to be resolved, that you're resolving it by looking at our traditions, independent of a moral theory behind those traditions, and the best moral theory that you have. And it seems to me that both of you are saying something like that. But so, and if I'm wrong about that, I'd like to know. But my primary question is on the myth of strict scrutiny. Oh, and I'm wondering, can I push? Okay. Sherry thinks, and I just don't remember, that strict scrutiny is explicitly referred to as Zawacki. And then the three of us were wondering whether that was an equal protection case or not.
It is an equal protection case. But its mechanics are not that of strict scrutiny. They don't talk about compelling governmental interest and necessary relationship. They look for a sufficiently important governmental interest. So it's something more like intermediate scrutiny, even though Marshall uses the words fundamental right. Okay.
So I think we'll both take a run at this. I don't know that I have a lot to say. when I was listening to Jim on this, I was struggling to figure out exactly what the terms of this disagreement are. If it's that that any strict scrutiny that would claim that you can just mechanically apply a set of rules, that sort of the reasoned judgment that Harlan spoke of can somehow be drained out of the thing, and that even might be the goal, that is neither normatively attractive nor does it actually account for the court's constitutional practice, I think he would find both Mike and me in complete agreement with that, and the book not trying to suggest to the contrary. If, on the other hand, the claim is that the court, doesn't always operate with perfect analytical clarity, sometimes unintentionally, sometimes intentionally, perhaps, in these areas, I don't know that he'd find either Mike or me disagreeing with him on that either. I think then, though, if the claim is something like actually sort of notions of tiering or fundamentality of right in some kind of in a general way, also does not explain the court's approach in these areas, nor is it justifiable. There I think we're liable to have some disagreement. So I agree that the court, though, and academics, though occasionally, usually it is the academics who attempt more thoroughly to lay out the metes and bounds of what tiers of scrutiny would entail. And the court then sometimes gives lip service to that, but in actual cases it's not clear that it's just focusing on what's a compelling state interest and then just doing something that's recognizably narrow tailoring from one case to the next, say. Nevertheless, I think it's plugging into conceptions that do coalesce more or less around means and ends, and that do rank relative importance of ends, and that do ask for or do inquire more searchingly as to means if the infringement is going to be on an individual interest or an equality interest that the court takes to be especially important. So, just one example, Lawrence. It's true that Justice Scalia, in dissent, says, well, look, the court doesn't announce it's doing strict scrutiny, therefore it must be doing rational basis, therefore this is a preposterous opinion, and pretty soon people are going to start marrying cats. But that's not a faithful account of what Justice Kennedy's opinion actually does. I mean, he plugs into jurisprudential lines going back to Griswold and earlier, and he speaks of fundamental interests as he does so. The language of fundamentality is everywhere in the opinion, though he never says that particular liberty interest is a fundamental right. So I think this reflects Kennedy's sort of being mindful of the idea of these tiers of scrutiny, but not wanting to have to operate strictly in those boxes. I guess I continue to think, and I think the book defends the idea, that there's quite a lot that's sort of descriptively illuminating and accurate in speaking of those tiers, as long as we don't think that it's some kind of mechanical solution provider that could drain actual judgment out of the enterprise. I think on that I would absolutely agree, and I had not thought that the book was arguing to the contrary.
Let me just add a small normative justification for it. Right? I mean, I think the question is, it's less important whether we've exactly gotten the doctrine right or wrong, although I think we tried to get it right, than it is what's driving the move towards tiers of scrutiny. I mean, I think it's the recognition post-New Deal, right, that the basic setting of constitutional law is going to be deference, right, or ought to be deference, and that there are then going to be exceptional circumstances that call for some kind of more searching judicial review. Now, if you give that up, you end up with the position sort of the Cato Institute, right? There was this fellow here, I don't remember if it was from Cato or something like Cato, a few weeks ago that I ended up debating. And he's arguing that courts ought to be, striking down laws requiring motorcycle helmets and, basically any kind of infringement of liberty. And, it's a violation of people's fundamental rights to make them buy health insurance. And so what's at stake, I think, in the commitment to some kind of recognition that some rights are different from other rights is preserving, on the one hand, the basic functioning of democracy, including a lot of social legislation that I think we would like, and on the other hand, the recognition that there is, going to be a core of liberty that we're courts are going to defend.
Any other additional questions? Bob?
This is not my field, but I certainly learned a lot from all of the speakers, and a great MC as well. And this is sort of a follow-up to Professor Fallon's anticipating a defense from you guys about it's a small book. And I guess...
Not in the diminutive sense.
No. I guess I'm interested in, I'm not familiar with the series, and I wondered, is this a book focusing on student readers, and if so, do you think it's a responsibility of an author to go beyond what's taught in the first year con law class, or are there other avenues for building in the kind of analysis that Professor Fallon and others were suggesting?
So the target audience, according to the marketing gurus at Oxford University Press, consists of law students taking the basic course in constitutional law, undergraduates taking the undergraduate course in constitutional law, and interested lay people. Right, which probably means that it'll, be ideal for nobody. So that aside, right? I mean, I think the answer is, of course, right? It would be better if it did more. It would be better still if it did more without being any longer.
Yeah, so I have to confess not to have read the book, so there's some risk that Michael's going to open a page and quote something proving me wrong, but I don't think so. And it goes to really Dick's point about what's going on in the political science department, comparing it with what's going on in the law schools. They don't communicate all that well. And I think one is there's some things that law professors traditionally should be and are a whole lot better at. Right, the nuance of the law, things like jurisdiction, justiciability, levels of court, state, federal stuff. I mean, it's very hard for political scientists to master the Supreme Court, much less all the stuff that we almost instinctively know, even though we don't know that we know it. On the other hand, the political scientists have been far more quantitative than the law professors. And so some merging of that, I think, some merging of the constitutional law expertise on panels like this and the skills of people like Lee Epstein and the others needs to occur for the law professors to be able to articulately respond to what political scientists say, because there's lots of information out there suggesting things like the attitudinal model only works at the Supreme Court and not in the massive cases, and the constitutional law as practiced at the ground level is quite different than constitutional law as practiced in the high court. But we as a discipline have not tooled up so that many of our most elite scholars are constitutional law scholars, but they don't have the tools to wrestle with the political scientists. So.
Let me just say one word. I agree with that, Ted. You won't be surprised to hear it. Mike's actually a really terrific example of somebody at the top of this field who is taking certainly more seriously than almost everybody else in our field what the quantitative folks are doing. And just one thing, at one point that he's made in earlier work that I know was in earlier drafts, and I'm pretty sure it stayed in the final one. Oh. Yeah, please. Or don't, so that I can claim it's terrible. So the one thing the attitudinal model, it looks like, turns out to be pretty poor at doing is figuring out which cases are actually so easy on the law that their model of politics doesn't really do much work at all. So there was that the study that the WashU folks put together a number of years ago that tried to get different people that had a computer predicting things on their model, and then
the experts,
sort of inside experts from academia. Then another group, what almost nobody talks about, is I think in a lot of cases the group that actually did best wasn't the computer and it wasn't the academics. It was Supreme Court practitioners in Washington. So those people are really good at predicting what the court's going to do. And maybe it's because of a blend of theory and sort of just political or other predictive capacity. But there were some huge sort of flameouts by the model. They were in cases that the model thought was going to be a close 5-4 political, hotly contested political thing. And they ended up being 9-0 one way or the other, because the argument on one side was just so laughable as a legal matter that the politics couldn't get off the ground at all. Happens that it was the term I was clerking was the year that they were doing that study. So there's this case that looked like it might have been the next big federalism case called Jenks versus Richland County. And it was Scalia who wrote the opinion saying that effectively states' rights argument is a total joke. And nobody could possibly think otherwise except certain members of the South Carolina Supreme Court. And so Mike's the one who's pointed this out. That one way to think of the sort of constraining that law does on politics is to define out certain things as just beyond arguability. And now that's, an oversimplification, but another way of putting it is easy cases is where politics doesn't do a whole lot of work. And that I know is in an earlier paper of yours, and I think that we found some place to make a look at it here, but if not, it's a good idea.
So I'm going to take the moderator's prerogative and ask a question that actually ties to Ted's and especially Dick's points about the relationship between political science and constitutional law. And it's also connected to the fact that you referenced Dahl in one of your responses. And I'm just curious if you could talk a little bit about the role of Dahl's ideas in some of these arguments, because one can see a clear connection between a focus on the idea who decides and Dahl's classic political science book in the early 60s, Who Governs, where, like you, it seems that Dahl rejects the idea of there being clearly a counter-majoritarian difficulty because, in point of fact, there is no such thing as a majority, that the public is made up of a series of coalitions that connect depending on the issue at stake, and so it's a pluralist moment of bargaining, and that institutions are more or less relevant based on which is the best site for pluralist bargaining. And I'm just curious about how that tradition in political science, which actually, despite all the criticisms, continues to this day in arguing about the way that coalitional politics rather than the majoritarian one is really the central avenue for thinking about the political system, connects to your arguments about the role of the judiciary as a centerpiece for constitutional liberty.
Right. So I think there's some really good descriptive legal scholarship on this. I think Mike Harmon's work is the best in the field on this. And, making the point that the Supreme Court doesn't act in a counter-majoritarian way. What it does is it takes sectional consensus and imposes it on outliers, and he's done that. And there are other people who say that sort of thing. I think the place where, I think that stuff is extremely relevant. I think the place where we have hard work to do as theorists, and maybe this is a place where I can consider leverage whatever comparative advantage legal academics have, is then making the normative case for some set of institutional arrangements given these realities. Because the way it goes back to this sort of little paper I'm writing, that I see the core problem as we have justifications for a practice that we don't have, right? But we don't have justifications for the practice that we do have. And you can see this in Barry's book. I think Barry's book is wonderful. But at the end, he comes to the very end of this, his is not a little book in the diminutive or any other sense. And he comes to the end of it, and he's like, well, now that we've been through, we might ask, well, what's the point of judicial review after all? And then he sort of says, oh, well, and that, it seems to me, right, is the real question, right? Given all of the political constraints, you could imagine, it seems to me the place to get started, it's just sort of popping into my head now, so it's probably half-baked, but the place to get started on this, right, is actually Federalist 10, right, which is the font of our thinking about the role of interest groups and how the structure of the Constitution responds to that. But, I don't know where that's going to lead and what kind of, whether that ends up being, takes you to a place very critical of our practices or one that is somewhat more supportive.
So thank you very much for a wonderful hour-and-a-half session, and thank you for all the speakers coming and for the wonderful comments. So, congratulations.